All right, welcome back. Well, a little light today. Where is everyone? Yeah, priorities, I guess, right? So, okay, well, those of you here, I appreciate it. For those of you who are not, you'll be missing out on the good stuff. Let's see. All right, any questions? What's in your mind? Anything in your minds? Anything bothering you? Okay. Griswold, at Meyer, Lochner, any of the case we did last week? Anything in your minds? Yes?
I was wondering if you could put into historical context what happened with the Supreme Court from like the early 1900s up until these cases started. Reading the cases about, even fiction as a part in regards to race. Like I felt like in those cases, the court was really hesitant to sort of go in and change things, and they were really relying on legislative action to get all of that stuff done. But in these cases, it seems like the court is just kind of like, we're going to do this.
Making it up as they go along?
Yeah, just do whatever.
Okay. Your question is an excellent one, right? What happened on the court from the early 20th century to the 1960s and 70s, what we're talking about now? I'm going to lead off with that in 30 seconds, but you had a question too? This question will take me longer to answer. This one might be a little bit easier, maybe, I don't know. Really? You both did the same question? Okay, then I'll start that way. All right, any other shorter questions? This is a somewhat lengthy answers involved. You don't make it easy, that's okay. So if any of you ever comes to my office, and hopefully you will at some point this semester, it's remarkable that of the 7 even, but I do have an office with doors that opens up. So for those of you who actually do come to visit me, on my wall, I have this really huge poster. Some of you may have seen it. And it charts the justices throughout the last 200 years. And it kind of looks like a sine wave, right? It charts how many presidents appointed Republican, how many presidents appointed Democrats. And at various junctures in the history, it kind of went up and down. When the court tends to have more conservative justices, as a general rule, the court does less stuff. They are less involved in making up new rights and finding this and that. And at other points, when the court has more liberal justices, they do kind of go on their own, which I think is what Jocelyn's question was getting at. So the question of what happened to the Supreme Court of the 20th century is something that will fill many books, and I couldn't even begin to do justice to it. But in many respects, I think it's a product of the presidents who appointed the justices. So the judges in the early 20th century, for the most part, were fairly conservative. And I don't mean like, Republican conservative. They were not eager to have judges move too far too fast. Often what's viewed as the exception to that is the Lochner cases, where the court said we have this liberty of contract and we can invalidate laws that violate this liberty. But for the most part, as you saw in some of the cases leading up to Brown, they were hesitant. They said, I don't know, if we move too far too fast, we might lose our legitimacy. And then we even saw in a case like Cooper v. Aaron, right, with the Little Rock Nine, the children trying to go to school. You needed the National Guard to come in and escort the kids into the building. But then something interesting or different happened starting in the 1960s. And this is a birth of what's generally known as the Warren Court, named after Chief Justice Earl Warren. So President Eisenhower had a momentous opportunity to replace Chief Justice Vincent, who passed away. And he picked a popular Republican governor from California by the name of Earl Warren. Warren was Republican, but he seemed to be fairly moderate, and Eisenhower put him on the court. It was under the stewardship of Earl Warren, along with another justice named William Brennan, also a Republican from New Jersey, go figure, that the court took a sharp turn to the left. And during the 1960s and 70s, in one decision after another, the court began pushing the envelope of every single social issue you can imagine. Criminal procedure, pornography, birth control, abortion, voting rights, etc., etc. And one case after another, the court began to inject itself in the most divisive issues of our time. What about the admonition of Lochner? Remember this terrible case, Lochner, where we have these judges substituting their judgments, right? Aren't we supposed to be done with that? Aren't the courts simply supposed to defer to majorities unless there's some sort of political process that's broken down? Griswold more or less marks the time when they said, whatever, screw it. You remember there was a dissenting opinion saying, wait a minute, you guys. We are inserting into our vision of the Constitution whether birth control laws should be allowed or not, right? We have to look to the penumbras from the emanations, right? These rays of light shooting from the Constitution. In case you don't mind, I don't have any penumbras coming from mine. It's pretty dark. For the most part, there's nothing coming from it. But the court said that this is our job. And if you'll notice, and I don't mean this as a slight, but the opinions you read today probably drove you nuts. You're thinking, oh my God, what the heck is the holding, right? Oh my God, what clause of the Constitution they're relying on, right? Oh my God, where does this come from? This stuff about bearing and begetting children, right? Where is this coming from? And by large measure, and to use Jocelyn's words, the court said, we're going to do it ourselves. No longer content to let the democratic process work out this issue, they decided to reach in and adjudicate issues that probably were not even justiciable in many aspects of life. So that was the Warren Court, okay? But every action, like Newton said, has an equal and opposite reaction. And in large measure, because of the excesses of the Warren Court, we move on to the 1980s. President Reagan was elected. And in large backlash to the conceived excesses of the Warren Court, we got the Berger and later Rehnquist courts, and now Roberts courts. And if you look at guys like Nino Scalia and William Rehnquist and others, these people grew up in the era of the Warren Court, liberalism and activism, as they called it. And they said, we need to dial this back. So when you have 3 consecutive Republican presidencies with the Reagan and then Bush 41, we have new justices appointed to the court who see the law differently. And they say, no. This is not for the courts to get involved with. And you see them trying to chip away at precedents like Roe and many others we'll discuss later on the First Amendment and religious prayer and stuff. But then we reach something of a turning point, which is, of course, the case I signed today, Planned Parenthood versus Casey. This was a case where you now had 7 possible votes to return Roe, 7 votes to get rid of it. And the court blinked. And in a joint opinion by Justices O'Connor, Kennedy, and Souter, all Republican appointees, they said, we're not going to reverse Roe. They basically did. They didn't say it, but they said, we're not going to reverse Roe. And even now, to the present day, much of what the court does is still perceived as saying, we don't want to be like the Warren Court, right? We don't want to make stuff up and do all these cockamamie rights and privacy and penumbras, right? So the story of the 20th century Supreme Court is really one of cycles and ebbs. I can say this without any hesitation. In 2016, there'll be 3 justices over the age of 80. The third will be 78. The next president may appoint 3 or 4 justices to the court. This is generational. This is a, to quote Joe Biden, a big effing deal, okay? Because effectively, the opportunity that George H.W. Bush blew to replace William Brennan and Thurgood Marshall, he blew it from his perspective. The next president will have to replace Ruth Ginsburg and Nino Scalia and Anthony Kennedy, which is then the entire world will blow up. That confirmation fight, just go to your bunker, just dig deep, get your rations, because it's going to be hell. I mean, I can't even imagine. Hope it must be 120 because I'm dreading that day. So, Jocelyn, to answer your question, it's been one of cycles. And this is not saying that the courts are political, and I want to make that point very clear, but if you're a president, your most enduring legacy are justices. The thing that lives long beyond your 8 years is a justice. Chief Justice Roberts may serve for 40 years. Same for Kagan. She's quite young, right? They may serve 40 years if they're healthy. That's 5 times the length of a presidential administration. So in large measure, the court changes based on the politics of the country and who's appointing judges. And how future judges react is how they'll perceive of what we're doing today. You know, we'll do a case in a few weeks called Citizens United. That was a 5-4 decision. I can easily see that one getting reversed very easily if another justice comes on. Justice Kennedy becomes, justice someone else. And that raises the important question of precedent. To what extent are judges bound by precedent? If that's not the lesson of Planned Parenthood, I don't know what is. When people rely on precedents, we leave them in place, perhaps even if they're wrong. Okay. This was not meant to be a comprehensive history of the court in the 20th century. Books and books and books have written on this topic. But the focus for today, which is on Eisenstadt v. Baird and Roe v. Wade and Planned Parenthood versus Casey, at least the first two, were the product of a court of a different era that was intent on whatever. Just go for it. Get the result. Doesn't really matter how you get there, and worry about it later. And then when you get to it later, say, oh, well, we've had this one too long. We can't get rid of it. And that's more or less the state of where we are today. Uplifting for 9 in the morning. Okay, what else? What else is on your mind? Andrew? Yes, sir.
What are some of the decisions that kind of show that they're backing off, or that they have backed off from the substantive due process type stuff?
So there's other cases which we're not going to spend too much time on, but one of them is called Washington versus Glucksberg, which considers a right to assisted suicide. And the court effectively imposed a test saying that this is not such a right because this is not a right that's deeply rooted in our history and traditions. The court, again, has never actually reversed any of these cases, but they dial them back and they stop recognizing, I can use that word, new fundamental rights. They kind of put that on hold. Yes, Sarah?
I mean, it does have rights to whatever the genetic modification or whatever. Like if they have baby, oh, we don't want this thing. It doesn't want to leave the life. It's going to be born.
Let's ask me that question after we start discussing Roe, okay? Or Casey. Yeah, ask me in 30 minutes, okay? Yeah, I don't. It's an interesting discussion, but we'll get when we get to Roe and Casey. Other question before we start? No? Okay, so let's start. So for review, right? Last week or whenever it was, last class. I have no sense of time, by the way. Days blur together. So in our last class, whenever it was, we discussed the case of Griswold v. Connecticut. And where did I finish up last time? Oh, perfect. Okay. So up top, yeah. So Ryan, what was the holding in Griswold v. Connecticut from last class?
So the Supreme Court found right of privacy was in the 13 Amendments.
In the what amendments?
The Third Amendment, sorry. Prohibition against the
Well, it wasn't just Third Amendment. Where did this right of privacy come from the court? What was that? What was that fancy word they used? Come on, you can see the light. Say it. The penumbras, yes. So, yes, among them was the Third Amendment, the prohibition of quartering troops. But the court said that there's this right of privacy which exudes from the emanations from the penumbras from the Bill of Rights. You have the First Amendment, the Third Amendment, the Fourth Amendment, the Fifth Amendment, the Sixth Amendment, the Ninth Amendment, and 14th, all these other provisions of the Constitution. When you put up in a pot and you boil it together, it shoots out a zone of privacy or something like that. Okay. With respect to the law at issue in Connecticut, it was a law banning the prohibition of contraceptives, right? Did the court hold, William, that that law was constitutional? Was that law valid? Connecticut law?
No, because it regulated the privacy.
Yes, and that's the key holding. Remember, I made a point of stressing this over and over again. The court said this regulates the privacy of married couples, right? Everyone with me so far? Right. In the opinion, did they say that the state could ban it for unmarried people? Oh, I'm sorry. Well, yeah. Did the court say that they could ban contraceptives for unmarried people?
They could, if they could do it all at once. Wait, they couldn't because they were banning for unmarried couples?
What was the right identified? Who had the right to contraceptives in that case?
It was married couples.
What about unmarried couples?
They didn't have the right.
Okay. Very important point. In Griswold, this right of privacy was between husband and wife. That was the entire nature of the right identified. The right of husband and wife to have contraceptives in the privacy of their bedroom. Right? The state said very clearly, the court said very clearly that the state can regulate unmarried people. They can prohibit fornication. Fornication's non-marital sex, right? They can prohibit non-married people from using contraceptives. The entire purpose of the right was for married couples. Everyone get that? Okay? Brett, how long did this entire married thing last for? This entire married right thing last for? I mean, how long did the Supreme Court stick to that line that only married couples have this right to privacy? What year was Griswold? What year was Eisenstadt v. Baird?
72.
How many years is that?
7 years.
7 years. So in the span of 7 years, that's not a very long time, my friends. Maybe in your life, 7 years is a lot, but in history, 7 years is not a very long time. In the span of only 7 years, we go from holding that this right to privacy applies to married couples to meh, whatever. That is the case of Eisenstadt v. Baird. The entire premise of Griswold was the right of married couples to have contraceptives, then whatever. You can't discriminate against unmarried people. Okay? This is, I think, what Jocelyn was alluding to. The ends justify the means. It doesn't really matter. If we get to the right result, it's unnecessary. And oh, by the way, just give you a little preview. Hugh, go back up top. Why do you think in 1972, the year before Roe, the court had this opinion saying that you can have this right for unmarried couples? Why do you think in 1972, the year before Roe, the court had this entire discussion of why unmarried couples have the right to contraceptives? What do you think they were getting ready for? Think about it. What happened the next year? No, 72 is Eisenstadt. What happened the next year? 73. What case were you assigned to in 1973? Hugh, why do you think it was necessary for the court to establish this right extends to unmarried people as well? I don't know that. Think about it. Why do you think it would need to go that far? Oh. Yes, why? Yes, everyone see that. Can you imagine the court in Roe v. Wade saying, oh yes, only married women can get abortions, unmarried women can't? Do you imagine that holding? That wouldn't make sense. So Eisenstadt was a pit stop on the way to Roe. Right? It was a pit stop. We got, just get rid of this entire married, unmarried distinction, and let's let this right apply to everyone. It was a game, right? Again, William Brennan, who offered the opinion, Eisenstadt was a master logician. There was a great story. One of his clerks said, Justice Brennan, what is the law? And he said like this, give me 5 fingers, and I'll show you what the law is, right? 5 justices, that's what the law is, and that's what they believed, and that's what they did. Okay? So Eisenstadt was a pit stop on the way to Roe, a conduit, if you will. So let's talk first about this case, which the facts of Eisenstadt are very interesting. This is William Baird, who was a prominent birth control advocate. He's known as the, quote, father of the abortion rights movement. And actually his story is interesting. He, in 1963, he visited a Harlem hospital in New York, and he saw a woman screaming in the hallway with a, quote, coat hanger protruding from her uterus. Baird recalled that she died in my arms. And this is what motivated him to become an advocate in this realm. So he bought a truck that he called a plan van, and he drove around the poorest cities in New York City and elsewhere, giving information about birth control to people. He wasn't a doctor. He had no medical training. He had no licensing, but he was motivated to go around and give this information. He was arrested a number of times for giving contraceptives to people. This is him when he was a little bit younger, and here he is protesting about abortion. The case we have here arose in 1967. Okay, so roughly 5 years before the case goes to the court. He gave a speech at Boston University to a bunch of students in the room. Okay, he spoke about contraceptives, and he gave one of the students this vaginal foam, which is a form of contraceptive, not a particularly effective one, but it's a form of contraceptive. What you'll notice about this advertisement, which is authentic, it says EMCO, used by more women than any other non-prescription birth control product. Okay. Hey, let's see if anyone notices it. What's interesting about this ad?
Wedding ring?
Wedding ring. See? Wedding ring on the ring finger, right? Everyone see that? Why is the model for the birth control foam wearing a wedding ring? What do you think, Lauren? Yes. In many states, including Massachusetts, contraceptives were limited to married couples. Okay? In fact, I found this really interesting advertisement, which is fascinating. It's an ad for the vaginal foam, right? But it picks a much younger wife with a much older father delivering a baby. And the caption says, 3 reasons for spacing your children. In other words, this was viewed as a way for married couples to plan their parenthood, which is where the name of the group comes from. Yes, sir?
So this will not stop the spread of disease?
No, it didn't. And in fact, there were different laws about birth control, about contraceptives to stop spread of diseases, and contraceptives would prevent pregnancy. The contraceptives that stopped the spread of diseases were, for the most part, legal. But the law distinguished, and they said if it's meant to prohibit conception, contraception, stop conception, right? It was meant to stop conception. Yeah, I never realized that, right? It was meant to stop conception. That was different. What?
How do you make that decision?
Google it. I don't. That's above my pay grade. Above my pay grade. Not going there. Not drawing any pictures today. Anyway, this was actually another ad I found, which again shows husband and wife. Why should our birth control method control us, right? This was actually an early advertisement for the birth control pill as well, which people were not crazy about at the time. Pictures, right? So anyway, I'll leave this up for a minute. So he distributed to a female student at Boston University. They only discussed the opinion of foam. They actually apparently gave her a condom as well as a foam. Okay. He was, yes. Well, let's be precise though, right? He gave a lecture, right? Gave a lecture on birth control, and he handed to one student. All right, so I don't know, we don't actually know if she was a student. She handed to one female the foam and also a condom, which wasn't in the opinion, but he gave that to her as well. Okay, so we get the facts, right? Well, that's actually a disputed point, but he actually handed it to a female. That's a fact. He handed it to her. That's the point raised one of the dissents, which I'll get to later. I'll get to later. We don't know. We don't know she's married. There's nothing in the record say that she was married. We have no idea. We don't know who this person is. Okay. So he was then arrested for doing this. Okay. All right. So everyone get the facts, right? No, he was arrested. I'm sorry. No, he was arrested for doing this. Okay. So Plowman, what were the laws that he was accused of violating?
The first was for dealing with foam because it was illegal to do so. But that was, I think, overturned on a First Amendment ground.
Well, no. Be precise. So there were 2 things that he did, right? First, he gave a lecture to roughly 2,000 students about birth control.
Right.
Plowman, was there anything problematic or illegal about him giving that lecture?
No.
Well, under the law, was it illegal? What was actually prohibited? Not only were you not allowed to distribute birth control, you couldn't even give information about it. You couldn't even advise people about it. Okay? So I don't want to dwell on this point much, but Plowman's correct. The court found that's a First Amendment violation. That giving advice about medicine is speech. I will pause and note very briefly that giving legal advice, right? There's a reason why you're all sitting in front of me. You want to be lawyers, you need to come here. You need to pass the bar. Just because you're speaking doesn't mean you can do it without a regulation under our system of laws. Lawyers and doctors give advice, but it's advice of such a level of magnitude that you need to go through training and certification together. That's why you're sitting in front of me suffering every morning, right? Okay? He was not a licensed doctor. So totally apart from everything else, he probably should have been charged with the unlawful practice of medicine. Totally apart from everything else, right? Yeah.
You can't like educate people, like there's different.
If I go up and I'm not a lawyer and I start giving legal advice, I can be charged with the unlawful practice of law.
If you're just a person and you read something and you
No.
sure you understand.
Medical advice is actually very different. There's actually a case now that's serious.
Well, I take Advil and stuff, but
You-
they have a headache, and
I'm not joking. So there's actually, everyone know what the paleo diet is? Everyone know about this, right? Okay, so it's a type of a diet where you have to eat like a caveman, whatever, right? There are these food bloggers, right? And there's one food blogger in North Carolina who's basically giving advice on how to use the paleo diet, saying it'll be more healthy for you. The North Carolina governor tried to shut him down, saying he was giving unlawful medical advice. I don't think you realize how regulated speech is. We'll do speech later. But generally, if I'm going and telling people and advising them to use different kinds of prescription birth controls, these are prescription drugs, at the time, I was engaged in lawful practice of medicine. Job.
This one says it's non-prescription.
He also discussed some stuff as well. I think under Massachusetts law, you needed to have a script to even get this. I don't know what year this one's from. But I think under Massachusetts law, you actually needed a prescription for some of these products.
But is that a determining line?
No, I don't think it is. Giving medical advice without license is probably illegal. People do it all the time, but it could be criminalized. Scary, right? But yeah, think of the paleo blogger who can't blog about the health food because of it's giving medical advice. Yeah. The case is going through the courts now, but they shut down his blog. The last year or so, maybe the last 2 years.
How does that work with? I mean, I get medical advice, but I feel like those would be like nutritionist or something like that. Doesn't that qualify?
To be a nutritionist, you have to be licensed. You can't just become a nutritionist. Yeah.
Yeah, but I'm saying
You need to be licensed by the state.
So how's that?
The state has to license you as a nutritionist. You need to go through certification and testing.
No certification whatsoever?
No, it's a random blogger. Right. Even if I have my own blog, my own website. I mean, I'm a lawyer, but let's say I wasn't. If I give legal advice on my blog, I could be charged with unlawful practice of law. I don't think you realize how regulated speech is, which is not what I want to talk about, but it's a big issue. Yes.
I was going to ask, I just feel like on Instagram now, there's so many people that are like posting what they eat every day and telling people like, do this, eat healthy, and
Maybe if the state wants to go after them, they probably could. Well, let's look at prosecutorial discretion. But let's put aside for a moment the actual lecture. That's not so important from my perspective, right? What I want to talk about is the fact that he actually distributed these products, the foam, right? So under Massachusetts law at the time, it was illegal, right, to give contraceptives like this unmarried persons, right? A doctor, not some guy with a van, right? A doctor could give these prescription products to married couples under the law. But a non-doctor was prohibited from giving it to unmarried people, okay? So, Lauren, did you notice what year this Massachusetts law was enacted? They mentioned it briefly. That's an important point. What year was this Massachusetts law enacted?
Crimes against chastity.
The current law as it exists at the time. What year was it? You got it? Someone say it again?
66.
1966. What year was Griswold v. Connecticut? Yes. So everyone see this. Griswold, 1965. This Massachusetts law, 1966. Why do you think they changed their law the year after Griswold law?
They wanted to fit as closely with Griswold.
They have to act constitutionally. So what you don't realize is that after the court invalidates a law, the other 49 states have to update their statutes. You never think about that, do you, right? When the court invalidated Connecticut's law, the other 49 states to go back and revise their code books. to make sure that they were in compliance with the Constitution. Because if they didn't, they'll get another court challenge and have to lose and be on the hook for attorney's fees and violating rights. Okay? So Lauren, I'm sorry, so Sarah, if you were a lawyer for the state of Massachusetts in 1966, and you had just read Griswold, and you were advising your state government on passing new law, right? What advice would you give them? Say, okay, Griswold was just decided in 1965. Here's how you should change your law to comply with Griswold. What could you have said? Well, it's contraceptive, right? How can the state? No, I don't talk human rights. You're a lawyer for the state, right? What kind of regulations after Griswold could they enact consistent with the Constitution? For whom? Yes, exactly. If you were a government lawyer for the state of Massachusetts and you were asked, okay, we have this statute, it's probably no longer good. What can we regulate? What can we regulate? You're a government lawyer, you say, you know what, Mr. Governor? We can still regulate contraceptives for unmarried people. The Supreme Court just said a year ago that we can have regulations for unmarried people. So Massachusetts enacts another law in reliance on Griswold. They're trying to follow the law in good faith, right? In good faith, they're trying to follow the law, comply with the Constitution, listen to the Supreme Court. Everyone get what happened? The very next year, they enacted a law. This is actually good governance, right? So Demi, what happens then 7 years later after Massachusetts studiously tries to follow Griswold? No, not Roe v. Wade, right? It's 1972. What happens to Massachusetts' efforts to make the birth control work? What case are we studying now? That's okay. Right. And what did the Supreme Court say in Eisenstadt v. Baird?
They said that you can't distinguish between married and unmarried couples.
Yes. And again, I'd apologize to keep going back to Jocelyn, but this is her question, right? In 1965, the court has an opinion saying that you can allow this right of privacy only for married couples. But don't worry, states, you can still regulate it for unmarried couples, right? This was clear as day. Anyone who read the opinion would see that. Only 7 years later, talking about stare decisis, right? Standing by precedent. Only 7 years later, that entire thing kaput. 50 states relied on that when they enacted the new laws after Griswold. And then kaput. The holding from Eisenstadt is that you cannot discriminate against singles. You cannot discriminate against unmarried women. Everyone get that? The entire holding of Griswold was premised on that you could treat married and unmarried couples differently. Come to Eisenstadt, the court says you can't do that. Yes?
But you can treat married and unmarried couples differently in other ways.
Oh, you stole my next question. Keep going. Explain more.
I don't know, maybe like taxes or something.
Yeah. Yeah. My God. Yes. You stole my very next question. Thank you. So I'll go back up to Haley, not so she can go out of rotation. Haley, we discussed equal protection, right? And just to recap, what are our 3 levels of scrutiny in equal protection?
We have strict scrutiny, qualified scrutiny, and rational basis.
Intermediate scrutiny is the middle one, right? Which is for quasi-suspect classes. Okay, so we said, right, strict scrutiny is for race and religion, intermediate scrutiny is for gender, and then rational basis for everything else. Haley, where does marital status fit in there?
I don't know. I mean, there's a part of me that wants to say gender, so it falls in the intermediate scrutiny, but it could also fall into everything else because it's not specific.
Okay. Ian, what do you think? Where's marital status fit in? Okay, interesting. Okay, what do you think, Connor? This would be the scrutiny game, right? How would you consider whether you're married or not?
I would say the rational basis.
Okay. All right. Let me ask this question to Jacob. if I am saying that and I'll use Stephanie's example, right? We're going to give a different tax rate to married couples and unmarried couples. So we want to incentivize marriage. Remember, states do that, right? We want to give a different tax rate. Are we treating them differently because they're men or women? If you're married, you get a different tax rate.
It's like some couples, never want to get married, they never do. They're happy that way. So you watch it.
But is that a gender classification? What do you think, Christian?
I don't see one.
What do you think, Christian? Is this a gender classification? No, privacy is a right. Let's talk about just classification first. We'll get to due process in a minute. But as a matter of classification, is this a classification basis of gender? Okay, so I think all of you have pretty good answers. But the court does not say that this is gender discrimination. Even by the terms of Brennan's own opinion, he doesn't say it's gender discrimination. He says this is discrimination on marital status. And marital status, because it's not one of those suspect or quasi-suspect classes, goes into everything else bucket, right? And Maurice, what screening do we apply for the everything else bucket? What kind of scrutiny do we apply for everything else that's not strict or intermediate? Rational basis, right? And generally speaking, Maurice, what is the government's burden under rational basis? How do they have to make their case? They don't. Right. This is the example we keep using. Driver's license, right? Age. Can the state say 17-year-olds get licensed, 16-year-olds can't? Sure, why not? Can the state say that married couples get one tax rate and unmarried couples get a different tax rate? Sure, that burden falls on unmarried couples, right? But the state can rationally decide that that promotes, I don't know, healthy families, whatever the state might decide. So this case presents an outlier for you from equal protection. The court employs scrutiny here that is not rational basis scrutiny. Justice Brennan holds that this imposes a discrimination on unmarried couples. It's a classification against unmarried couples. Rather than employing what we would call rational basis scrutiny, which means government wins, he employs something that looks like strict scrutiny. He goes through every rationale offered by Massachusetts, one at a time, and explains, nah, that's not good enough. Nah, that reason doesn't really make sense. Nah, I know better, I'm William Brennan, right? Basically, one after another, he second guesses the wisdom of the Massachusetts legislature, which again was trying to comply with Griswold. They were doing their darndest to comply with an opinion he joined. And then 7 years later, say, nah, not good enough. Not good enough. Okay. Questions so far? I'll stop for a second. He didn't call it that, but if you look at the analysis we'll discuss about 15 seconds, that's basically what he was doing. Yeah?
So I'm getting confused on we're using equal protection clause here to classify people, but this is substantive due process.
Ah, yes. The other aspect of this case is confounding, right? The other aspect of this, I'll go up to Brandon. You're next anyway, you're close enough. Brandon, let me ask you this question. Why isn't this case about the right to privacy? Why isn't this case simply saying that you have this right to get, birth control, and it's your body, your choice, liberty interest? Why do you go through this silly equal protection route? Why couldn't they just say that this liberty interest protects married couples and unmarried couples alike? Okay, good. Morgan, I guess you're up now. Let me ask you this question. Why did the court have to break this down? Why did the court in 1972 not simply say everyone has a liberty interest in privacy? Yes. What were they waiting for? Which was 1 year later. Again, Pit stop, right? Pit stop. They knew they were going to decide Roe. That case had actually already been argued. They held over for re-argument. They basically waited another year to do this first. I'm not joking. I wish I could make this up. They were basically holding on to cases so they can do this other stuff first and lay the framework for something else. William Brennan was known for laying they're called bombs. He would put these innocuous sentences into opinions, which he would then cite later to make into a really big thing, right? I'll point out the sentence. It's a bit long about bearing and begetting children. Bearing means birth. What does birth have to do with getting foam? We're talking about abortion. So Morgan's point's correct. They needed this opinion, which doesn't really make sense by itself as a pit stop to Roe. Because when you get to Roe, it's like, oh, wow, we have this liberty interest which we can't limit to married women. Piece of cake. We have this due process privacy interest that cannot be limited to married women. Piece of cake. What?
Isn't this kind of like what we talked about in manipulation of the court?
Yes, yes. I mean, I don't like being too cynical, but this opinion, there's a great quote by John Hart Ely, who was one of the most famous law professors of the 20th century. And John Hart Ely said of Roe, and this is not my words, this is not constitutional law and gives almost no sense of an obligation to try to be. We can debate the merits of abortion, pro con, and I will take no position on that issue here. But the way the court achieved this is tantamount. I don't use the word manipulation, but it's using the courts in a very, very suspicious manner. And this isn't just me, Mr. Right Winger, saying this. There was actually a book published about 10 years ago by a bunch of liberal law professors called "What Roe Should Have Said," and it was an imagination project. They tried to rewrite the opinions from Roe based on knowledge and information available in 1973. It's an interesting book if you want to read it, called "What" by Jack Balkin, who's the editor. What Roe Should Have Said, right? How could the court have protected a right to abortion without going through all these somersaults and making stuff up? Another point I want to stress is that one of the most prominent critics of Roe, someone you might not expect, is Justice Ginsburg. She's criticized Roe for 30 years in a very interesting aspect. She said the court moved too far and too fast, that the American populace was not ready for this wide-ranging right to abortion. And one thing which you may not know is that the Christian right and evangelical right was born, no pun intended, from Roe. It basically was spurred because there was such a backlash to this opinion. So putting aside whether we agree with the merits of the case or not, the actual politics in which it was decided is very difficult to reconcile with any notions of how judges should behave. But they got the result. Sarah?
I read in the book that one of the
Yes, so Professor Andy Koppelman, who's a friend that I know at Northwestern, he's argued that, well, let me explain it. He's argued that requiring a woman to carry a child to term is a form of slavery. They're actually putting her into involuntary servitude by forcing her to carry a child to term. Law professors have a lot of time on their hands, I suppose. But I think nothing else, that demeans the legacy of slavery in a way that I think is almost insulting. Yeah, no, not you, but him. Yeah, I think it actually demeans the legacy of slavery. Speaking of the 13th Amendment, SeaWorld, right? PETA, or some group like them, brought a suit against SeaWorld claiming that enslaving Shamu is slavery. That keeping Shamu in the tank, the orca, is a form of slavery. And because the 13th Amendment doesn't say persons, the 13th Amendment applies to animals. I am not joking. There are people who are trying to say that primates are protected by the 13th Amendment. Anyway. So everyone see what's going on here, right? So this was an equal protection opinion, not a due process opinion, but it really was a due process opinion applying some sort of strict scrutiny. Okay. So the court walks through different rationales for why this law exists, right? They say, first of all, right, this law is not about deterrence, right? Why? So fornication, which is having basically sex outside of marriage, that's no longer a crime in any state. But the punishment for fornication was much less than the punishment for birth control. Brennan says, how could it be that fornicating, the fine is $30 and 3 months in jail, and the fine for birth control is 5 years in prison? If they were really interested in deterring out of wedlock birth, they wouldn't have this structure like this, right? They wouldn't make it so easy to get convicted. And even then, that the person who gives the birth control is punished 20 times more than the person who actually fornicates. How can that possibly be about deterrence, right? Lauren, what's the response to Justice Brennan? How would you respond to that? His opinion, that seems pretty persuasive. How would you respond? Yeah, how would you respond to that if you were in the dissent? You might not have 5 fingers, but you could tell Justice Brennan all. What would you say to him? Brennan says this is not about deterrence. The people who actually engage in premarital sex have a smaller punishment than those who give out the birth control. How would you apply that?
A level of responsibility. The people that are giving out are held to a higher level of responsibility.
Okay. Zachary, what do you think? How would you respond to Justice Brennan? There's a really easy answer here, and it's a lot easier than you think. What? There's a really easy answer. How would you as a judge reply to Justice Brennan? Who determines the proper punishment for crimes? Not judges. See, this is a problem with law students, the judges. No. The response to Brennan is, this is actually a serious fault of law students. All you ever study are judges and opinions. You never read actual legislative stuff. The legislature decides what the proper punishment is. Who are we to decide that 3 months for this and 6 months for that is right or wrong as judges? This is none of our damn business. No one's arguing there's an Eighth Amendment argument here.
When it comes to punishment, at some point,
we're talking death penalty. Yes, this is okay. So the Eighth Amendment's a totally different issue, which we don't talk about this class. But put that aside for a second. When the state decides this form of punishment is better than that form of punishment, this month versus that month, there's no Eighth Amendment issue, right? The right answer is this is not for us to decide. If the legislature wants a structure like that, who are we to decide that they're right or wrong? What's lurking in the background here, right, is Lochnerism, but they don't want to admit it. The same rationale where the state says, oh, wow, we want to have a maximum hour of 60 laws. The court says, no, that's not good law. Here they're saying, no, you can't have the 5-year penalty. That's too much. Goldilocks, too hot, too cold, a little bit too much. The exact same substitution of judgment that takes place in Lochner is going on here, where the court's saying, we don't agree with how you structured your law because we don't think that's the real reason, right? We don't think that's actually what you're getting at. There's no way to avoid it, and the court just dances around the issue. So ultimately, they invalidate it on equal protection grounds by saying that married and unmarried women have to be treated equally. And by this, they extend the penumbras from Griswold to all women. Yeah, this was a pit stop, and I think that's the easiest way of looking at this case. The most important sentence, though, as is often the case with William Brennan, comes at always the end. He's very good at this. And I'll read it to you very slowly. If the right of privacy means anything, it is the right of the individual, married or single, to be free from unwanted governmental intrusion into matters so fundamentally affecting a person as a decision whether to bear or beget a child. Read it again. If the right of privacy means anything, it is the right of the individual, married or single, to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as a decision whether to bear or beget a child. In this one sentence, he sets the stage for Roe. He first says, married or single. It no longer matters. The state no longer has an interest in treating married and unmarried women differently. And then he says, bear or beget a child. If you haven't read your Old Testament lately, you may not know what those words mean. But beget means to conceive, and bear means to give birth. So this isn't just about contraception. It's about giving birth. Where does this come from? Who's talking about abortion here, right? Who's deciding whether or not they can give birth to the child? Pit stop. This little sentence would be cited barely a year later by Justice Blackmun, no relation, majority opinion. No, it was spelled differently. Okay. So I'm going to get the holding of Eisenstadt. Any questions on the holding and Brennan's opinion? Okay. Justice Douglas concurs briefly and says that, well, look, this is just about the First Amendment, and this is actually Sarah's point before. The doctor was just demonstrating how, what these products were. With respect, these weren't visual aids, right? This wasn't like holding up a prop. He actually gave the products to a female for the purpose, presumably, of her using it at some point. Who knows what she did with it, but he gave it to her, presumably, to use. This wasn't like he handed her a prop and then took it back. He gave it to her, deliberately trying to violate the statute. This was what he was trying to do. Justice Black makes also the point that I think Stephanie or Sarah made before. We don't know she's married, right? What if this woman was married? Let's just vacate the conviction because there's no evidence in the record that she was married or not. Okay? This is silly, right? The reason why this is silly is because this case would come up in a different situation, right? This is a dodge because they didn't want to rule on this issue. But yet, a year later, they ruled ahead in Roe. So whatever. Yeah.
So when these cases or cases similar to these are decided, are there like a whole bunch of cases being brought in different states?
Yes.
Is that kind of how it works?
So what's interesting about the Supreme Court is they have a largely discretionary docket. They can pick and choose which cases they decide. And they can decide, we'll have this case, we'll hold this case, we'll do this case now. Here's Morgan, where they can manipulate the docket. Right? They can hold on to cases. We discussed Brown v. Baird. Right? Brown was argued twice because they didn't have enough votes the first time. So they re-argued it after the Chief Justice died and Warren replaced Vincent. Here, Roe was argued twice, and they got all the votes lined up. There is a cynicism, which may be descending upon you, about the court, because they're able to tweak their docket and do this case, not that case, and hold this case, wait for a case with better facts. And there's something to be said about that. Yes, Morgan?
It seems like an unfair separation of powers issue. Because if you think about it, the executive branch has the power to elect the judiciary, and when they're there, and as long as they have good behavior, the legislative branch has no say on how the justices are pulled in. How does that work?
So in the past, the court has had a much less discretionary docket. In the past, Congress has said that the courts are required to take certain kinds of cases. That doesn't really exist today, but they do exist. So when the court is required to take a case, there's no requirement of how they decide it. So very often, I'll give you a good example. I think I told you this. We'll do gay marriage soon. Who here knows the Supreme Court already ruled on gay marriage 30 years ago? Who knows this? Anyone? Anyone? Case of Baker v. Nelson. Case of Baker v. Nelson from Minnesota. A gay couple walks into the city hall and they ask for a marriage license. They're denied. They say, wait a minute, the marriage law of Minnesota says nothing about men and women. It just says two people can get married. It's actually gender neutral. Deny marriage license. They sue. Goes to the Minnesota Supreme Court. Minnesota Supreme Court says this is ridiculous. There's no gay marriage right. There's no equal protection violation. This is ridiculous. They appeal to the Supreme Court. The Supreme Court at that time could not decline certiorari. They couldn't turn the case away. What they did was instead issued a one-page opinion that said this case presents no substantial question of federal law. In other words, this is such an easy case, there's no actual federal constitutional law here. There's no question to resolve, dismissed. So actually the courts ruled 30 years ago that gay marriage poses no substantial question. Whether this case is valid or not, different question. But for a large time in history, the court was required to take a lot of cases. Today, that's basically gone. The court is an almost entirely discretionary docket. They can pick and choose what cases they want. They can wait for a case that fits their fact pattern preferences and they call stuff on. It's very tricky in the end. Yes. There are a small number of cases. So, for example, the McCain-Feingold Campaign Finance Act provides an automatic appeal to the Supreme Court. You get it. But they don't have to issue an opinion on arguments. They can just issue one of these short one-page opinions. I'm sorry, the McCain-Feingold Campaign Finance is like campaign spending. And there are certain civil rights statutes which still have a direct appeal to the Supreme Court. But these are very rare. I saw another hand somewhere. Yes, Zachary?
I thought it was in Texas, but did you hear the case? It was like in the 70s. Two couples with a gay couple of married license, but one of them dressed in drag.
Yeah.
So when they went to get their certificate at the courthouse,
Yeah.
there was a man and woman that issued a certificate, and they tried to say that the state's going to take it back because they didn't know that.
Yeah, I guess this stuff happens. I think I heard about that. Anyone else? Okay, so what's interesting is the Chief Justice's dissent, Chief Justice Berger's dissent in Eisenstadt makes the point that this is like the heyday of substantive due process. He's basically saying this is Lochnerism, right? The exact same substitution of judgment that the court employed in Lochner is being done here. The state shouldn't have to justify why they choose this punishment for this crime and that punishment for that crime. That's the prerogative of their elected branches. Okay? And in the end, he says, what provision of the Constitution are we relying on? What provision of the Constitution are we even citing here? He says, this passes beyond the penumbras into personal predilection, right? This is not about some sort of fancy pants penumbras. These are judges making stuff up, is what the dissent says. Bizarrely, a year later, he joins Roe v. Wade. I still can't figure that one out. But the Chief Justice here was upset. Okay. All right. Any questions on Eisenstadt v. Baird? Again, this was just the book calls it a transitional case. I call it a pit stop. Call it whatever you want. But this was a means to an end. Any questions on Eisenstadt? All right, let's move on to Roe. This is probably one of the most controversial cases in Supreme Court history. I would put it up there with Dred Scott, Plessy, and a couple others. Not in terms of good or bad, but controversial, generate controversy. The reason why this is controversial is the reason why this is a difficult topic to discuss, because abortion is a very sensitive and personal issue for good reasons. And people have very wildly differing views on this topic. And I respect all those views. And as I've noted before, I'd like, if we can, and it's not always possible, try and keep a focus on the doctrine and the actual test and the cases the courts are using. Inherently, in this case, the court runs into different philosophical, religious, and ethical debates. It's unavoidable with this topic. But to the extent I like to keep our discussion charted along the actual tests of this case, which is what we need to study. Okay. So the case Roe v. Wade, okay, her name wasn't actually Roe. That was a pseudonym, a fake name. Her name was actually Norma McCorvey, and this is actually a picture of her some years later. Here's a somewhat contemporary picture of her. Okay. She lived in Dallas, not too far from here, and she was not married, and she was pregnant. Okay. So I want to focus a second on the facts here because they're actually important. Did she get an abortion?
No.
The answer is no. What would have happened if she had gotten an abortion? No. Well, I mean, what else?
Oh, there would have been no case.
There would have been no case. So one of the interesting aspects of this case is that she needed to stay pregnant. Had she actually obtained an abortion, I mean, there were illegal abortions in Texas. They existed, right? Had she obtained an abortion, the case would have been mooted. This is why the facts of this case are actually somewhat sad. When she was first trying to get an abortion, and she actually testified before Congress to the fact, she went to these two lawyers who were, lawyers in town. And she said, I want to get an abortion. And they basically told her, don't do that because we need to follow the court case. They needed a plaintiff. So they used her as a plaintiff. And she actually, in a bizarre reversal of fate, she became a huge pro-lifer later in life. She actually became a stalwart opposition to abortion. Her child was put up for adoption ultimately. But the lawyers who brought this case used her as a plaintiff because they needed someone who actually wasn't going to terminate the pregnancy. Anyway, so she tried to obtain one, not really, because she knew she could have got one, but she filed a lawsuit in court, brought on behalf of her and, quote, all other women similarly situated. Yeah, there's a funny thing about pregnancies. Usually it lasts only 9 months, and most Supreme Court challenges last 4 years. So inevitably, every single time a woman's pregnant and would try to obtain an abortion, by the time the case gets to court, either it's over or it's not. So the court had to invent this doctrine of saying, well, this is a problem that's capable of repetition, but evades review, right? Because no woman can get to the court in 9 months. It's impossible. So basically, this case was brought on behalf of all similarly situated women who are attempting to get a legal abortion and cannot. Okay? The Texas law that was in place effectively banned all abortions except in the interest of saving the life of the mother. And this was a fairly rigid standard. This means the mother will die. Not that she will become sick or have some postpartum depression or whatever else. She will die unless the abortion is provided. So the situations in which it was permissible were actually very, very limited. Okay. So any questions on the facts of the case? So I'm sure if any of you have ever seen anything on TV, you always see the protesters saying, we support a woman's right to choose and save Roe v. Wade and all the other signs. What may have surprised you, and surprised me the first time I read this decision, was how little of this case was actually about women's rights, and how much of it was actually about the state's interest. Okay? And specifically, the court makes fairly clear that this is not about a woman's right to choose. That phrase is not really even part of the decision, even though that's become the cultural bellwether of this issue, support a right to choose. Instead, the opinion is largely about at what point does a state's interest in the fetus's life become sufficient enough to justify the law. Okay? So the court's analysis itself is somewhat Griswold-ish, and that's topsy-turvy. The court begins by saying, again, the opinion was like Justice Harry Blackmun, no relation, and they say that these laws invaded women's right to privacy. And where's this privacy right come from? The liberty provision of the 14th Amendment, substantive due process. And to support this, they looked at cases like Griswold and Eisenstadt. Okay. In the end, though, the court finds a way of resolving this issue with a framework. Okay. A framework to decide at what stage of the pregnancy does a state have an interest in regulating and prohibiting abortions. And the important part of this is that they separate gestation between viability and before viability. Okay. The 3 trimesters of the pregnancy are the basis for the framework. So the first trimester, the first 3 months, are viewed as a time where the state has very little interest in regulating an abortion, really none at all. Right? The second trimester is where the state maybe has some interest with respect to the mother's health. But the final trimester, final one, the state's interest in protecting the life of the unborn child becomes greatest. Okay? This is more or less the basis of the court's opinion. Not to put it too mildly, this is very similar to what a legislature would decide. If a legislature was assigning the issue of abortion, perhaps dividing up into trimesters is a correct framework. Perhaps it's not. How does the court justify constitutionally this framework? They look to this right of privacy, right? They do this Griswold analysis. They look to the First Amendment, the Fourth Amendment, the Fifth Amendment, the Ninth Amendment. All of these cases which represent different privacy and liberty interests are guarded. But in doing so, they lump all this into a general umbrella of the right to privacy. And this isn't the right of privacy between husband and wife, which is really interesting. It's a right of privacy between a woman and her doctor, right? Gone are this notion that what happens in your bedroom is private, which is what Griswold said. Here, the privacy is a relationship between a doctor and her physician. I'm sorry, a woman and a physician. The dissent makes the point that there's not much private when one's going to a doctor's office and having all these procedures done. But the majority of the opinion by Justice Harry Blackmun says this is the essence of privacy. Okay? The court rejects arguments that this is an absolute right, that a woman can get on-demand abortion at any point. The court rejects this. The court also rejects the idea that the state has interest in the life of the child at any point. Rather, the basis of this decision is the state's interest in the protection of the mother's health. The state has an interest in protecting the mother from unsafe procedures, right? Not, primarily at least, to prohibit abortion because perhaps it's wrong or unethical. What's interesting is that actually, and I apologize, they cut it out of your book, but there's actually discussion of Buck v. Bell. Remember the sterilization case we did last class? And the court says, right, hey, look, these women are arguing they have an unlimited right to do with your body as you wish. My body, my choice, right? Has the court respond to that argument? Buck v. Bell. You think it's your body? Nope. If we want to sterilize you, we can. So the same opinion, which ostensibly gave women a right to an abortion, reiterated that the state can choose to sterilize you if they want to. There's a perverseness there that I don't need to dwell on for too long. But the exact same rationale that the state can protect the health of the mother could also be used for the state to sterilize the mother. And if that doesn't give you pause, I think perhaps it should. Okay. So the court holds that this right of privacy includes abortion, but this is a unqualified. Yes? Is your hand up or no?
I read it as once the baby or fetus is supposed to be done, the state retains the health insurance.
I'm not sure that I understand your point. The part I'm discussing actually was not in your casebook. They edited it out, unfortunately, which I think was a mistake. But there was a discussion in the opinion where they favorably cite Buck v. Bell, and they discussed that it's not really your body, right? That it's the state has an interest in your health, and the state can decide if you're feeble-minded that you should not reproduce. And this case is favorably cited. Yep. Yeah. I mean, I read the original opinions, but the book editors often cut stuff out that I think is important, and that's why I have to try and supplement it when I can. So the holding is that you have this qualified right to abortion. You have this qualified right to access this procedure. So what do we do about scrutiny, right? We discussed last week, or whenever it was last class, that with due process we have fundamental rights and non-fundamental rights. Is abortion a fundamental right? Court says yes. What happens when a right's fundamental? You apply strict scrutiny. Okay? And what happens to laws that are subject to strict scrutiny? The government loses. So the government basically, the court basically says these regulations on abortion are fundamental rights and basically will get strict scrutiny. And the state's interest only comes in later, basically after the point of viability. They don't resolve the thorny question when life begins. One thing which is actually helpful to the majority opinion, the 14th Amendment, right? It says, all persons born. Born, it says it right there. You're a person when you're born. So is a fetus a person under the 14th Amendment? Well, the court basically says no. Does the state still have an interest in that in the fetus's life? They don't resolve that. Yes.
Well, it's not to ask, isn't it interesting that there's a fundamental right for women against men, but then I remember that it's a medical privacy thing, so I guess men and women still have, I think, because fundamental rights, aren't they rights that, like, can be applied to all people, but if it's about medical privacy, then I guess it can be applied.
So we discussed gender a week ago, and the court said in the Virginia case that there are inherent differences between men and women. I think I said this. I can never give birth, no matter what I do my entire life. I will never be able to have birth to a child. So a fundamental right in this sense is something that only women can bear, no pun intended, right? This is only right only women can have. The court goes on, though, to say that this isn't really, though, about marital privacy, right? This is more about the relationship between a woman and a physician and the state. Nothing to do with marriage. So here we have it. The court then breaks down this trimester framework. In the first trimester, no regulations, right? The only thing the state can do is license doctors. Here, I'll write this out, make it easier for you, so we'll come back to this in a few minutes, right? So row, right? So first trimester, basically no regulations. The state can do just about whatever. The state can basically do nothing. Okay. The second trimester, right? These are the second 3 months. There can be regulations for the mother's health. Okay, what does this mean? They can make sure that there's certain procedures that are not dangerous to the mother. Again, this is not about a woman's right to choose. This is about the state's interest in protecting the mother's health, not the child, not the fetus. Okay. What about trimester, right? What about the third trimester? Third trimester is post-viability. And the state has an interest in regulation. In other words, once the third trimester kicks in, there's actually some sort of actual, perhaps interest of life to protect. And the state can regulate that. And in case you want to know, at the very end of the opinion, there's what I call the press release, which summarizes the opinion in bolded form. You don't see that very often in Supreme Court decisions. It says, here, 1, 1A, 1B, 1C, 2. I call that the press release because that was for the New York Times. They're basically trying to summarize the opinion so that everyone could read and understand it. This was meant to go far beyond the Supreme Court press corps. Okay? Here we have our 3 categories. So first trimester, basically, no regulations. It's between the women and the doctor. Okay, in the second trimester, they can regulate it in a way related to the mother's health. And only in the third trimester, when you have viability kicking in, at that point, you can regulate it to promote human life. Okay. Yes? If there's a procedure that may harm the mother, if there's a dangerous procedure, it can be regulated. Yes. Yes. So in other words, under the framework, and here I'll show you, this is how the New York Times, right, By the way, it's funny. The day Roe was decided, Lyndon Johnson also died, so it didn't even make top billing on page A1. But it says court rules abortion legal the first 3 months. The first 3 months, basically, no regulations are allowed. The second 3 months, if there's perhaps a dangerous procedure that may harm the mother, the state can step in to make sure that procedure is not done. But that doesn't mean, and this is the important part I want to stress, during the second trimester, the state has no interest in human life. I'll make that point very clearly because it'll matter for Casey. The state cannot pass a law during the second trimester under this law with an interest in protecting human life. That's not a legitimate interest. The only interest kicks in after viability. That make sense? Who do you think decides? Well, the legislature can take their best stab at what procedures are dangerous, but ultimately it's the judges who will agree or not. Because the judges will have to decide, is this actually for the mother's health? Right? Is this procedure actually for the mother's health? Or is this law actually secretly trying to promote human life? And if the court finds this is actually geared to promoting human life and not for the mother's health, the law is invalid. Right? What this basically does is give judges a license to decide what's the true purpose of the law. Is it protecting health or promoting life? And if it's promoting life during the second trimester, the law falls. Yes?
Do we ever make a distinction between potential life and actual life?
The court doesn't. They use a viability line. But they use the phrase, and you're correct, potential life. They use that phrase over and over again.
What if someone's actually living their life more viable?
What do you mean actually living?
Well, like the woman is obviously like she can live outside of, prenatal care. I don't know much about that, but like a fetus in the third trimester, baby, that's still potential life relative to the mother who's actually walking around the world. So if they value life, what I'm understanding is they value potential life.
They're talking about the life of the fetus, not the life of the mother.
Because the state interests their health and understanding potential life versus the actual life.
Well, the court said in every case, if the life of the mother is in jeopardy, abortion is allowed at any month, even the 9th month. Right? Even in Texas before Roe v. Wade, if the life of the mother was in jeopardy, abortion was permitted. So that's the when I say human life, I'm talking about the life of the fetus, not the life of the mom. Well, what did the court say in Eisenstadt? Was concerns about chastity valid? So it's interesting. It's in Griswold, right? In Griswold, the court said laws banning fornication are fine. The court ducked that issue in Eisenstadt and addressed it here. But does the state have an interest in protecting fornication, chastity, prohibiting, I don't know, sodomy? We'll see 20 years later in Lawrence v. Texas, the answer apparently is no. So even then, the state still had an interest in protecting morality, but they couldn't do so through these laws. Other questions on the majority opinion Roe? I won't dwell on the logic of the opinion too much because there isn't much. The same type of analysis used in Griswold and Eisenstadt of making stuff up gets you to this framework. And if you want to read it, you can read it, but it's not very important. What's important is actually understanding the press release and the framework that came at the end. Yeah.
Griswold, did the attorneys bring this sort of number argument, or did the court just kind of make it up? I mean, where does this come from?
I've actually researched this issue, and there was some law review article which talked about cores and penumbras of rights. Justice Douglas just kind of made it up. I mean, it was based on some law review articles, but it basically was whatever.
It wasn't in the brief.
I haven't read the briefs, I don't know, but it was not well researched. Yes, ma'am. Yes.
I was gonna say, I think I met the attorney that was actually Roe's defense. I think she said she used that case. Like I think they built up those amendments, but they created them.
Yeah, I mean, this was a deliberate pattern. I mean, Planned Parenthood had a litigation strategy. They start with birth control for married women, then they go to birth control for unmarried women, then they go to abortion. I mean, you have a litigation pattern, a strategy. Similar to with Brown v. Board, right? Thurgood Marshall said, all right, we're going to start with schools, then we'll go to lunch counters, then we'll go to this and that. I mean, you build up incrementally. This is lawfare, using law as a form of warfare. You have a strategy, and you can achieve certain goals through a very deliberate pattern. And this was the culmination of Roe. This was what they were building to for a decade. Okay, any other questions on the majority opinion of Roe? The concurring opinion by Justice Stewart is interesting because he basically, identifies the huge elephant in the room that wants to talk about. Justice Stewart says, this is Lochnerism, and I'm damn proud of it. Right? I know in the past we said we wouldn't use the substantive due process stuff, but yeah, we're doing it, and good for us, right? I'm proud of it, right? This law is invalid, and we can strike stuff down that violates liberty. So at least I appreciate Justice Stewart. He was candid. The others, not so much. Justice Rehnquist, who had been on the bench at that point, maybe a year or so, he was on the bench for Eisenstadt, dissents and says, this is ridiculous, right? This is Lochnerism. We're supposed to be applying rational basis scrutiny to these types of cases, right? This is not some sort of right that impacts the political process like voting, right? Under footnote 4, this is not a political process right. This is a social right, the same right as liberty of contract in Lochner. How can we do this and not that? The majority opinion in Roe opens up by quoting Justice Holmes's dissent in Lochner. But in reality, Rehnquist writes, they are relying on the majority opinion by Justice Peckham in Lochner. Rehnquist says that this 3-trimester framework amounts to, quote, judicial legislation. Right? You're actually dividing things up the same way a legislature would. He says, listen, we've banned abortion for a century, for 100 years. This thing's been banned. How can it be that this constitutional right, which existed for 100 years, wasn't recognized by any point till now? At the time of the 14th Amendment, Texas law was in effect. How did no one realize that this law violated the 14th Amendment till now? Okay, this is, again, the debate between living constitutionalism and any kind of originalism. Do we limit our rights to based on how things were understood at the 14th Amendment? And the rejoinder to that is, well, there also were segregated schools at the time of the 14th Amendment. So there's a back and forth here. Okay, Justice White's dissent was based on democracy. He said, listen, you've now taken at the hands of all 50 states the ability to decide this issue for themselves, right? No longer can the people decide what their best regulations are and how their society is structured. The court now sits the super legislature. He says this is an exercise of raw judicial power, right? This is a point that Justice Ginsburg made long before she was on the bench. By moving so quickly with Roe, and you mentioned the 8th Amendment, right around the same time the court found the 8th Amendment permitted all death penalties. Okay, these decisions, allowing abortion and prohibiting the death penalty, and that's two sides of the same coin, had a massive backlash, and people were very angry. The death penalty decision was reversed. A few years later, the court said, oh, just kidding, you actually can have the death penalty, because there was such immediate backlash. We've made this point a number of times, but courts only exist so long as the legitimacy is valid. And when they rule too far, too fast, and reach into issues people are upset about and personal about, they take things away from the people, and there's a serious crisis that emerges. Just because you like the outcome in a case doesn't mean the court should be doing this. And if you learn nothing else from me, that's what I'd like you to learn. But whatever you think about abortion, that's fine. But the issue here is whether the court was in a proper place to rule in the manner they did and supplant laws in all 50 states on abortion. Because once this came down, basically every state in the union had to revisit their abortion laws. Even though many of the states have been liberalizing and providing more access to abortion, this case basically derailed that. And people started saying, oh, well, let's find other ways to limit it within this framework. Like, we can ban this procedure and require informed consent and this and the signature of the husband, all these other things. Oh, yeah, for the mother's health, we have to give this information. You have to wait 24 hours to read it, right? All these laws came about as a direct reaction to Roe. What happened if the court hadn't decided Roe in 72? What if they waited 5 or 10 years? What would the laws have looked like? I don't know, probably similar to what we have today, but without the huge impact of the case itself. And again, yeah, John Hart Ely, who was one of the famous constitutional law professors of the 20th century, said that this case is not constitutional law and gives almost no sense of an obligation to try to be. I spent very little on the actual merits of the case because it didn't really matter much, and that's about all I have to say about that. All right, any questions on Roe?
Courts only exist as long as their legitimacy is valid. Is the reasoning in Parenthood?
Yes. Oh, the irony. I'll get to that in about 2 minutes. Exactly. Good point. There's a serious irony there, right? Any other questions on Roe before I move on? I promise I'll get to Casey in a minute. All right. So in the decade, or actually say in the 2 decades after Roe, there were a number of cases, and you don't need to know all these cases because they don't really matter now because of Casey. But there were a number of cases which involved states trying to regulate abortion in creative ways. So, okay, fine. Roe made this framework of trimesters. How can we get around that? Well, what if we allow or require that the father of the child has to consent to the abortion? Nope, court struck that down. Right? What if we say that minors can never get abortions? Well, nope, court struck that down. You need to have the minor, that a minor can't get abortion without a parent, right? The court struck that down, saying, no, you need to give the minor a judicial bypass, that the minor can go through a judge to get the abortion because maybe the parent's abusing him or whatever. The court did say, though, that states and the federal government don't have to fund abortions. So some people made the argument, wait a minute, the government funds pregnancy and childbirth. Shouldn't they also fund abortion? Isn't this gender discrimination? Creative argument. And the court said, no, there's an obligation to subsidize abortion. This is still a huge issue with respect to Obamacare. And as Obamacare stands now, the government cannot directly fund abortions, although in certain respects, the company is required to provide for contraceptives that do have the impact of terminating pregnancy. So that does exist. Right? What happens if the law says you need a waiting period? If a waiting period for a gun, why not a waiting period for an abortion? Wait 24 hours. These laws have the effect of basically making women go to a doctor, go back home, wait a day, go to the doctor, and get the procedure. For women who live far away from these things, this is a big deal. There's actually an issue in Texas now. Texas passed a law which imposed certain health and safety laws saying your abortion clinic must have these admitting privileges and this and that. The effect of the law was to shut down almost all, not all, but a lot of the abortion clinics in the state. So some women have to drive 5 or 6 hours to get to a clinic. And if there's a period of driving, does that pose a burden, right? Some states have laws involving informed consent, saying before we give you an abortion, we need to give you some information, you need to sign it, you need to say that you read it, and you need to wait 24 hours. Okay? Throughout the 1970s and the 80s, virtually all these laws were invalidated. The court basically was saying Roe's the word. But then in 1989, we have the case of Webster versus Reproductive Health Services. This case involves 2 new justices, O'Connor and Kennedy, who were not in the court. And they were somewhat moderate Republican appointments. But in that case, the judges signaled that maybe Roe is not good, right? Maybe Roe can be reversed. Okay, that's the backdrop leading up to 1992's case of Planned Parenthood versus Casey. Having 3 consecutive Republican presidencies has an impact on the court. You have new justices. You now have Sandra Day O'Connor, Antonin Scalia, Anthony Kennedy, David Souter, Clarence Thomas. The face of the court changed. And ostensibly, there was a shift to the right. And by all accounts leading up to Casey, there were 7 votes to overturn Roe. 7 votes to overturn Roe. What happened next is miraculous. I discussed in my book the switch in time that saved 9, the Chief Justice changing his vote to save Obamacare. Folks, that's nothing compared to Casey. So let me tell you a story. The initial vote in Casey was to invalidate Roe. That initially there were enough votes in Casey to overturn Roe v. Wade. David Souter replaced William Brennan. People didn't know much about Souter. They thought he may be conservative, turned out to be liberal. But the big one was Clarence Thomas, replaced Thurgood Marshall. Thurgood Marshall, the sign of the NAACP, was replaced by Clarence Thomas, right, the most conservative justice in the court today. That changed the face of the court. But then a compromise was struck. Even though the initial opinion was to overturn Roe in its entirety, to get rid of it, a trio formed. Sandra O'Connor, Anthony Kennedy, and David Souter. They changed their votes and created what became known as the joint opinion in Planned Parenthood v. Casey. What the heck is a joint opinion? You notice? Not one of them signed it individually. Usually it's the opinion by Justice Scalia joined by so-and-so, right? No. This was one opinion offered by all three. Where have you seen a joint opinion before? Obamacare. Remember the joint dissent from Scalia, Kennedy, Thomas, and Alito? That they were all so angry they didn't even put their names, so they all signed it together? These are the only two joint opinions in recent memory. I can't think of any others. And through this opinion, they changed their votes. And there's this great story in a book called Supreme Conflict by Jan Crawford. So believe it or not, Justice Scalia and Justice Kennedy are neighbors. They live in the same block in Virginia. And there were these rumors throughout the court that Justice Kennedy was about to change his vote to uphold Roe v. Wade. And there's this great story where Scalia and Kennedy are going jogging, right? They're just walking outside their house going for a jog. And Kennedy promises Scalia, don't worry, Nino, I got this. Don't worry, I'm good, I'm solid, right? The next day, Nino goes to court, and there's a draft opinion on his desk saying that we will uphold Roe. So, very serious effect on fracturing the politics inside the court. Justice Scalia, if you could tell from the dissent, was absolutely livid. He often is. He was indignant. He was like, this close to getting rid of Roe. This close to killing Obamacare, sensing a pattern, right? At just the last minute, the justice said, no, we're not going to do this. It's fascinating to study from history, but even more interesting from a legal perspective. So the joint opinion comes out to save Roe. But does it save Roe? This is Morgan's question, which he posed a moment ago. This is how the court brokered a compromise. On its face, it say over and over and over again, we are upholding Roe v. Wade. We are saving Roe v. Wade. Again, I put up on the board for a reason, right? What is the holding of Roe v. Wade? What is the thing that everyone knew was a holding of Roe? You have these 3 trimesters. You have the first trimester, no regulations. You have the second trimester, only regulations for the mother's health. The state has no interest in life. The third trimester, finally a state has an interest in life. So after viability, you can have regulations on abortion. Did the court uphold this framework? No. No, 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 no. So if you want to be really smart-ass, right? Someone says, oh, we need to save Roe v. Wade. Say, oh, no, the court already overturned it, right? Roe is not actually good law in any sense of the word as we know it. The law is actually Planned Parenthood versus Casey. Casey instituted a new framework to understand abortions and regulations on abortion. Okay? But it pretended in a way that some have described as disingenuous to uphold the core aspect of Roe v. Wade. So the reason why this opinion was so significant is not just for its discussion on abortion, which was very important, but for its discussion on precedent, on stare decisis. This was the court's most detailed discussion of precedent ever. In Brown, the court didn't say much about the fact that Plessy was a 70-year-old precedent that had to stay. In West Coast Hotel v. Parrish, the court didn't even mention Lochner, and that was getting rid of it. At that point, it was about 25 years old or 30 years old. But here, we're dealing with a precedent that was 19 years old and quite controversial. And the court had to address it. The first sentence of this opinion rings in my ear far too often. Liberty finds no refuge in a jurisprudence of doubt. That's how you start your essay, right? For your brief that's due tomorrow, right? Go start your brief with liberty finds no refuge in a jurisprudence of doubt. If you're a legal writer, like, what the hell is this? Take lessons from Tony Kennedy how to write. Do not take writing lessons from Tony Kennedy. Bad idea. We need clarity, not obfuscation. All right? So what does that mean, Jonathan, right? Liberty finds no refuge in a jurisprudence of doubt. What the heck does that mean? Liberty finds no refuge in a jurisprudence of doubt. What the heck does that mean?
Sounds to me like it's not like a solid rule, then liberty can't, I guess, exist on all plans.
Gabrielle, what do you think? Yeah, right? Thanks, Jonathan, right? Liberty, no, he's on the right track. Liberty finds no refuge in a jurisprudence of doubt. What on earth is Tony Kennedy talking about? Okay. All right, good. George, what do you think?
I agree with them that if we're not even sure on the theories that we're applying, then how can we be fuzzy on what we are applying?
Okay. So it's a weird statement. James, let me ask this question. Why do the courts have stare decisis? Why do the courts adhere and follow precedent? What's the purpose of stare decisis? But why? That's what they're doing, but why is that important? Good, right? There's a good opinion or a good quote in this case that says, excuse me, it doesn't make much sense. Every case, fresh eyes. Right? It wouldn't make sense for every single court to sign issue with fresh eyes, right? Pedro, why would it be a bad idea for every single case to start fresh and decide the case is clean? Why is that a bad idea? More importantly, why do you think as a litigator, you're going to be a lawyer in a couple of years, right? Why would you not want the court to make up a new rule every time a case comes up? That'd be a jurisprudence of doubt, wouldn't it? The jurisprudence of doubt is uncertainty. If every single time a court approaches an issue to something different, you're going to be lawyers in a couple of years. You're going to be doubt. What's the rule? What am I supposed to know? What do I tell my client? What are my rights? How can we structure our lives when the law is constantly in flux? When the law is in flux and every single time a new court case comes up, there's a new rule. How can we be free as people? So that makes sense, Pedro? All right, Gabrielle, let's apply that standard to the 1960s and 70s. Let's go to the question with Jocelyn and Morgan asked, where every other year they invented a new right. How can society be stable when every year there's new right being recognized as false law? Why didn't precedent matter to the court in 1972 or 1973? Why was precedent not important then? Is that any different than today? Then what, or 1993? What changed then, Gabrielle, between 1972 when Roe was decided and 1992 when Casey was up? What was the difference in society of why doubt in 1992 was bad, but doubt was awesome in the 70s? Morgan, take a step. This is your question. I punted on it. Why is it that a jurisprudence of doubt in the 70s was cool, hip, but a jurisprudence of doubt in 1992 was we can't have that? I want a better answer than that. There's a better answer. That's an answer, but I want a better answer. What do you think, Elliot? Why, and this is why the Kennedy opinion is important. Why is there a difference from 72 to 93 or 73 to 92? What's different that prevents us from having this doubt?
Well, I keep thinking about the context of what's going on during the time, but I'm not sure if I've heard it is maybe on board. General communication is better. People are certain it was
Not quite. Amanda, what do you think?
Well, I was thinking sort of along the lines of what you said, like I'm thinking about the political context instead of the one word.
That's an answer. That's not the answer I want, because the plurality, the opinion of the three judges, they give an answer to this question, and that's what I want to focus on. Don't focus on politics for a second, Amanda. What's the answer that the judges give in the plurality? By the way, when I say plurality, that means an opinion with less than 5 votes. It's a 3-vote block. Amanda, what do you think? What's the reason here? This is the important takeaway of the stare decisis discussion. This directly refutes my cynicism that all that change is a composition of the court. I'm not saying it's correct, but I want you to understand the answer. Want to take another stab, Morgan?
Yeah, I'm looking at this argument that only decisions like Brown and Roe these are perfect examples because of the significance of the question being asked.
Okay, you're on the right track.
So, because these are such serious questions that have such conflicting personal divisions, the court has to find that middle ground and draw that clear line, and they can't go back on what they said because of the impact it'll have on society from that.
Yes. The last thing you said was correct. They can't go back. They can't go back because of the impact it will have on society. Right? What's the impact of society of going back? Alana, what's the impact of society?
You say going back, you mean taking that
Overturning Roe. What is the impact on society?
well, I mean, women alone would just be
Well, I know they'd be upset, but specifically, what is the legal impact? Why is it problematic to go back? There we go. Jennifer, what do you think?
Would it make it like on abortions be convicted?
Well, no, that'd be an ex post facto issue, but because you can't be convicted for something else legal at your time. But what is the legal reason why going back would be so disruptive? And what's wrong with that?
Because it shows people that the court doesn't have as much power as it should. And if you can overturn something that they held, what's the point of it in the first place?
Megan, what do you think?
I think it's the states.
Well, this would actually be giving the states more power because now the states can regulate more. Mary, what do you think?
Is it because it will take away from liberty?
But what is the relationship of people to that fundamental liberty? Why is that significant? Why does it matter that the court's taking away a fundamental right? Why is that significant?
I think just by calling it a fundamental right.
What do people do when you call something a fundamental right? More so, what do they do when you call something a fundamental right?
That they would engage or
Good.
do things that they may be providing.
You're close, Job.
They start to base their life decisions.
They rely on it. Exactly. You were all really close, but yes, you rely on it. This is actually what Morgan actually almost said, right? You rely on it. When you have a precedent that's on the books for 20 years, as the plurality says, people rely on it. They base their lives on it. And Alana was hinting at this, but an entire generation of women go about their business with the understanding that this is in their background. That if something happens, this exists. That Roe exists as a backdrop. There's an entire social current of people who came of age knowing that this was a possibility. So it's not just because the court changed from Republican to Democrat. I mean, sure, you can be cynical and say that. I will if you want me to. But the court says we need to rely on precedent. Even if the decision of Roe itself was wrong, right? Even if Roe did not respect precedent, even if Roe reversed all these long-standing doctrines, we're here. 1993, Back to the Future, right? Part 3, I think, came out that year, right? 1992. We are in the future. And we can't go back because that will cause substantial disruption on what are called reliance interests. Reliance interests. People rely. Sarah? Well, some people may.
I mean, I just like, I think what you're saying about relying on the fundamental rights and stuff that we have in one decade and then still have in another, like, just as an individual, I would, like, organize my life according to risk diversity instead of thinking, oh, maybe, like, tomorrow, maybe this will be, like, my, whatever, like, that kind of, just because of the whole history.
Mm-hmm.
I'd say, I guess,
Okay, Joe?
So, every time the Supreme Court makes any sort of substantial ruling, they're changing something.
Yes.
And people have relied on that in the past because they expected things to be segregated or whatever else.
Isn't that an argument, huh? So basically, the argument, and just what Job was getting at, this has been around for 19 years. We can't get rid of it. Couldn't the same argument been said about Plessy? That Plessy has been around for 70 years. People are relying on it. We have an entire system of segregation. Let's not change anything. Let's not rock the boat. This is the point Scalia makes forcefully, right? Couldn't the same been said about Lochner? Wow, we've had this liberty of contract for 20 years. Had a great run. Nah, we don't need a new deal. Let's keep the status quo. The failing of the plurality opinion Casey is basically turns on its head how this argument's been used in the past. Because in the past, this argument's been used to keep bad stuff. And I was like, oh no, but we need to keep the good stuff here, right? It's this weird argument. Justice Thomas has long taken the position that stare decisis should not apply to any constitutional decision. Thomas said if something's unconstitutional, overturn it. Plessy was wrong the day it was decided. But here they're saying, even if a decision was wrong, not that it was right, it was wrong, we need to stand by it because people rely on it. Stephanie, your hand was up?
Well, if you kind of like, this is how I feel about like things like abortion, like if you let like the political route, like, take its course with the parties, I think it turns into like an issue of like religion, and it'll just never, ever, 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 ever.
Keep going. Whatever. Thank you.
Like, it'll never get solved.
But whose fault is that? But whose fault is that thing never gets solved?
I would say the political parties.
So then whose job is to fix that? The courts?
But, like, the
Ah. So if there's a problem, right? If there's a problem that never gets fixed, whose job is it to resolve that dilemma? The courts? There are some problems which will never fix a society, and that's because they're problems, they're divisive. Is it up to the courts to step in and resolve this? So let me we're running a little bit short on time. Justice Scalia's dissent, and I mentioned this once before, references another justice who tried to resolve a massive cultural issue. And some people try and say, oh, Scalia's comparing abortion to slavery. No, that's not his point. His point's actually much more precise. Roger Taney, this is a portrait hanging at Harvard Law School. You can go see it. It's a very powerful portrait. Roger Taney thought that by deciding Dred Scott and saying that the Africans were not human beings and they could not be persons, he was going to postpone or even eliminate the need for civil war. He thought by injecting the court into this matter of such national importance that he would resolve the controversy. And Scalia says, look at this Taney. Look at his eyes. He's just looking blankly. This was painted 2 years after he was Chief Justice. 2 years after Dred Scott. And he thought he could resolve the issue. Did Plessy resolve? I keep saying Plessy. Did Dred Scott resolve it? Absolutely not. Did Roe resolve the debate about abortion? Absolutely not. Did Casey resolve the debate about abortion? Absolutely not. Will the Supreme Court's decision on gay rights in a couple months resolve the issue on gay rights? Absolutely not. That when change comes from the court, people don't always accept it right away. And there's a serious risk that by injecting yourself, you might make the situation even more volatile so that you never, ever, 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 ever resolve it. Right? Anyway, so that's the point that Tawney makes, or that Scalia makes by Tawney. With respect to the actual abortion issue, though, the court says we are reaffirming the holding of Roe. Not really, though, because they basically get rid of the 3-trimester framework. Right? Now there's, pre-viability. Casey. There's pre-viability and post-viability. Okay. What's new is that you now have this new test. You have this undue burden test. Rather than saying there could be no regulation in the first trimester or some regulations in the second trimester for mother's health, now the state can regulate so long as it doesn't impose an undue burden on the access to abortion. What might also be called an obstacle. Right? That you can have different regulations on abortion, but they can't impose an undue burden. If it places a substantial obstacle in the way, it's unconstitutional. And if you're not sure, at the end of the opinion, use another summary press release where they just, it's at the end of the opinion where they describe letter A, letter B, letter C, letter D. You have this press release which describes it. So they reject the rigid framework of Roe. They stress that the state has an interest in protecting the life of the child. But pre-viability, they can't impose an undue burden. Okay? Yes, Elliot?
So, has this been applied to the new Texas laws about shutting down all the
This is going in the courts now. And the Fifth Circuit held that these laws are valid, that they do not pose an undue burden. Okay? I think there's actually a cert petition pending as we speak, and the Supreme Court may take up this case next year, or they may not. Questions? I don't want you to get too hung up in asking what's a substantial burden, because the court has been very, very vague about what that means. Is abortion subject to strict scrutiny? Not really. We now have this third standard, we always have to have 3, by asking, is a regulation imposing a substantial burden on the woman's access to an abortion? So it's not the case, like we'll be under strict scrutiny, that if there's a regulation of fundamental right, the government loses. Here, as we saw in Texas, these laws can win. Subsequent to Casey, there's a case mentioned in the notes involving partial birth abortion. If you want to know what this is, read it. But this is a procedure at the 9th month of pregnancy. And the court upheld a federal partial birth abortion ban, saying this was in the post-viability era, and the state could do it. So many regulations after Casey have been upheld. Many have been struck down. But this is the new test the court instituted. Okay? Questions? Yeah, the actual laws at issue in Pennsylvania involved like informed consent and parental notification and a 24-hour waiting period. The only provision that the court invalidated here was one that required women to notify their spouses of the abortion. They invalidated that provision because it imposed a substantial burden on accessing abortion. What if the husband's abusive? What if the husband doesn't want her to get one? They said that's no good. But informed consent, waiting periods, those are fine. Why are those fine? Because they can be said to be for the mother's health and for the life of the child. If we give women an opportunity to think about it, maybe she'll reconsider and not have the abortion. It may sound overly paternalistic, but the court recognized that that's a valid concern. Under Roe, that was not a valid concern. Under Plessy, you can consider the interest of the life of the child. The actual dissent in Planned Parenthood was by Justice Rehnquist and also Justice Scalia, and they say this is ridiculous. The entire notion that you're admitting Roe is wrong, saying you're upholding it, and then reversing it quietly is disingenuous. Okay? And Scalia basically says this is not law, right? This is not law that we're having. This won't end the controversy. And Scalia says we should get out of this arena. We have no right to be. Yes? There's a federal ban on them now, so it's in all 50 states. Interesting question raised by Justice Thomas. Is a federal partial birth abortion ban good under the Commerce Clause? How is regulating abortion interstate commerce? Justice Thomas said, hey, you guys, if you raised this argument, I was struck down the law. But you didn't, so nah. That's what he said. Go look. It's like one paragraph. He said, if you had raised this argument, I probably would have struck this down to the Commerce Clause. But they didn't do that. I don't think that's how they wanted to win. All right. Questions? No? All right. Have a wonderful weekend. I'll see you guys next week.